Okay, so whatever I'm bringing today to you is actually a long, a long hours of research and study that I have accumulated today to bring it to you, so that you can learn at a very fast pace about this subcontracting. Okay. Okay, so let's see what are the agenda for today's discussion. Today we are going to discuss on, first we'll start with the basics, and then we'll understand about different types of subcontracting, why subcontracting is done in projects. Then we'll understand about some of the disadvantages of subcontracting, cons of subcontracting. Then we will understand how subcontracting is dealt in various contracts, and what is the contractual implications of subcontracting in projects. Next, we will discuss about standard forms of subcontracting, subcontracts, right? As we have standard forms of contract, we have standard forms of subcontract as well. Next, we will discuss about some of the critical issues in subcontracting, uh, and finally, how to avoid the challenges of insolvency in subcontracting, right? So, and finally, we will take question and answers at the end of today's session. Okay, so to begin with the basics of subcontracting, let's understand what is subcontracting and who is a subcontractor. Okay, so subcontracting is basically subletting by the main contractor. It's transferring all the obligations to the subcontractor by the main contractor is subcontracting. And subcontractor is the person who agrees to perform some part or all part of the obligations of the main contractor. But is it that can all the obligations of the main contractor be transferred to the subcontractor? There are various forms of contract, those which don't support subcontracting at all, right? There are many employers as well, those who don't prefer subcontracting at all, because there are various disadvantages as well. But there are some procurement route where we know that there is 100% subcontracting, right? Like in management contracting, we have 100% subcontracting, where the contract is executed by the uh, works contractor, right? Okay. So if the subcontracting, so in a contract, it should be very clear, like what is the percentage of the work can be subcontracted by the main contractor, whether the employer is ready to take subcontractors in the package. If the subcontractors are appointed by the main contractors, what will be the form of appointment? What will be the type of subcontractors, uh, those which are means appointed by the main contractor in the project? So this should be very clearly depicted in the contract. Now let's have a look on different types of subcontractors. So top of the list is about nominated subcontractors. Okay, is my audio clear to you? Am I audible? Because I am getting some text in the chat box. Hello. Yeah, thank you. Thank you very much. So now let's have a look at different types of subcontractors. Like we have nominated subcontractors, and the concept of nominated subcontractor is dealt in depth in the FIDIC forms of contract. Next is named subcontractor. Named subcontractor is a concept which is dealt in JCT forms of contract. You can go through it and you can have a good understanding about named contractors. Then domestic subcontractors, work subcontractors, trade contractors, labor-only subcontractors. So who are these nominated subcontractors? Who are these nominated subcontractors? Nominated, as the name suggests, they are nominated by the client to the main contractor, right? So basically, in order to carry out some prime cost sum, right? Prime cost sum, sometimes client involve nominated subcontractors, and they nominate it to the main contractor, and the main contractor and the nominated subcontractor have contractual relationship between them, and the work will be carried out by the nominated subcontractor. Basically, it has been seen in mostly MEP works, specialized MEP works like some specialized light fixtures, or maybe expensive bathtubs, right? So there the client has their own choice of subcontractors, right? Those which are nominated, and they got into direct relationship, contractual relationship with the main contractor, and the material is procured through the nominated subcontractor. This is basically the concept of prime cost sum, okay, where nominated subcontractors are used. So in a specialized work, so why nominated subcontractors are used in a project? Why employers use nominated subcontractor? Because it has been seen that the employer gets benefit of their existing relationship with the nominated subcontractor. They can involve the nominated subcontractor early in the project, right, to have their inputs in the design and choice of materials. Sometimes clients have their advantage of economy of scale because they have procured materials from the nominated subcontractor in the previous projects, and maybe there are some agreements with the nominated subcontractors to procure materials in future. So that gives advantage to the client, and client has also control over the procurement if they do it through nominated subcontractors. Okay? Next is about named subcontractors. So named subcontractors are basically a list of subcontractors that is given during the tender. In the tender, it will be mentioned the tender, and it is given by the employer, the tender. So the main contractor can select a named subcontractor from the list of named subcontractor. So this concept is well elaborated in JCT forms. Okay. Now, so what's the difference between nominated subcontractor and named subcontractor? So both seems like same, because here both of them are actually endorsed by the endorsed by the client, right? Nominated subcontractor and the name, they're the choice of the client. Then what's the difference between nominated and named subcontractor? The difference is that in nominated subcontractor, the client is imposing the subcontractor on the main contractor, right? Imposing, like you have to get it done from this subcontractor. If Mr. Main Contractor, if you have any objections to carry out the work with the nominated subcontractor, you can let me know. So this is the concept of nominated subcontractor. And in named subcontractor, it's a choice of the main contractor from a list of subcontractors to deploy for a particular work. Okay. So this is the definition that is given in the RICS guidance note. A nominated subcontractor is selected by the employer to carry out part of the main contract works. Subject to certain conditions, the main contractor is required to enter into a subcontract with the nominated subcontractor. So here the payment to the nominated subcontractor is done by the main contractor. Okay. This is a named subcontractor. So named subcontractor is named by the employer in the main contractor and is employed by the main contractor to carry out the part of the main contracts. Okay. Domestic subcontractor. So domestic subcontractor is selected and employed by the main contractor. So in case of domestic subcontractor, the selection is in the hands of main contractor. Okay. There, so here the entire responsibility, all the responsibility of the performance of domestic subcontractor lies with that of the main contractor, because it is selected by them and they are employed by the main contractor. Now, in some contracts, even if you are deploying, even as a main contractor, if you are deploying a domestic subcontractor in the project, you need to take approval from the client whom you are deploying, right? So client also has the interest in the domestic subcontractor, as ultimately it is going to impact the project. Okay? Now there is works subcontractor. So work subcontractor is a subcontractor who is employed by a management contractor. Like we have already discussed in management procurement route, contracting procurement route, where we have seen that there is a direct contractual relationship between the contractors, work contractors, and the management contractor. So those contractors or the subcontractors uh, employed by the main contractors are work contract subcontractors. And similarly, in trade subcontractors, we have left out with say trade subcontractors. So trade subcontractors are all those subcontractors, those which are employed by the construction management, means construction manager in a construction management procurement group. Right? So that we have already discussed in the procurement and tendering competency. Next is labor only subcontractors. So these are basically the subcontractors, those who work with labors only. They are not involved in procurement or supply of materials. And next is about design consultants as subcontractors. So sometimes main contractors take assistance of designers or architects to do a part of their drawings. So they are also deployed uh, as subcontractors with the main contractors. Right? So in this design consultants as subcontractors, sometimes it happens that the architect or the designer who has worked with the employer during the concept design stage are novated to the main contractor. Because why it is done? Because that particular architect or the designer has a good knowledge about the project, because he was involved from the very early stage. So it's always better to get somebody who is involved in the project from the early stage. Hence, it is a very general practice that the client novates the designer who has worked in the concept stage to the main contractor during the execution stage. So sometimes in the design design and build type of procurement route, where the design is also in the scope of the contractor, there also the architect who was involved in the concept design stage with the employer was novated to the main contractor. So sometimes it is called novated design and build type of procurement route, right? Novation means it's a new contract where the rights and obligations of the architect has been transferred from the employer to the main contractor. So in APC panels, generally they ask about example of novation. Okay? So novated design and build type of contract is a good example of novation. It is a very general practice. See, this is there's a question by Karthik Babu. What is work subcontractor and trade subcontractor? What is the major difference other than the procurement management and the construction? See, basically the terminology has changed because of the difference in the procurement route. In both the procurement route, whether it's the management contracting or the construction management, it's the entire subcontracting, because none of the management contractors, like management contractor or the construction management, are involved in the execution of the work. They are totally managing the subcontractors. Now, those who are employed by the management contractors are work subcontractors, and those employed by the construction managers are trade subcontractors. Okay, so let's see how FIDIC takes on with the nominated subcontractor. So we have clause number 5 for nominated subcontractor in FIDIC Red Book 1999. So it says that nominated subcontractor means a subcontractor who is stated in the contract as being nominated subcontractor whom the engineer under clause 13 instructs the contractor to employ as subcontractor. Okay. So it's basically imposition of a contractor, imposition of a contractor to the main contractor, right? And here, while the imposition is done by the employer, the main contractor can object to the nominations as well. So objections can be done on the basis of the competence. If the main contractor is not sure about the competency or has doubt on the about the competency of the nominated subcontractor, so the main contractor can give it back in the writing about the objections on the nomination to that subcontractor. Also, if the contractor has not, the nominated subcontractor don't have sufficient financial strength or resources, for that also the main contractor can object to the nominations. Okay. There are two more eventualities through which the main contractor can object for the nominations, like if the subcontract clause don't mention about that the nominated subcontractor will indemnify the main contractor about any failure of performance. So if it is not there, then also this main contractor can object to the nominations. And the payment to the nominated subcontractor will be done by the contractor. Now, the selection of the right subcontract. So how we can select the right subcontract? There can be questions in the panels, right? Like how you will advise if you are working as a consultant, of course, or as a contractor, like how you can advise your management on the selection of a right subcontract, or if you are working as a consultant, how you can advise your client for the selection of a subcontract. So basically, for selection of the subcontract, the contractor has to identify the main contract. What is the form of main contract used in the project? Say, for example, if the form of contract used in the form of main contract used in the project is FIDIC, Red Book 1999. So it is advisable to consider FIDIC subcontracts as the subcontract form. Similarly, if JCT is used, we have different JCT subcontracts contextual to the JCT main contract used in the project. So identifying the main contract is very important. That is the first point. Second is considering the relationship between the main contract and the subcontract. Okay. Relationship between the main contract and the subcontract. As say, for example, like the rights and obligations in the main contract and in the subcontract will not always be the same. It will differ. Like say, for example, if in the main contract, it is obligations of the contractor to keep the client's documents confidential, right? So in the subcontract, it might be like protecting the information of the client, that is main employer, as well as the contractor. The obligation of the subcontractor is to keep both the documents confidential, not only of the employer, but also the contractor. So you have to understand like how the things will be dealt in the subcontract. Next is where the main contract is bespoke, give special considerations to the form of subcontract. Now, if your main contract is bespoke, okay, so generally what is done when the main contract is bespoke, the subcontract is also prepared as bespoke, okay? And it is seen in most of the contracts that it was back to back that is given. But even if you draft back to back subcontract, you need to be very careful while allocating the risk in the subcontract, and you cannot just simply blindly write this, draft the subcontract, like the same rights and obligations of the subcontract will be 100% transferred to the subcontractor. You have to be very cautious and very judicious while you are allocating the rights and obligations of the subcontractors, because all the things, all the obligations of the contractors may not be considered as the obligations of the subcontractors. Specifically in terms of payment durations, if there is a payment duration for the main contractor is more, like say for example, we have seen in FIDIC, there is a 56 days of payment window, right? 28 days for submitting the interim payment certificates, and then after interim payment certificate, there is within 28 days they will get the payment. So around 56 days of window, and then if we allow the subcontractor to come in uh, and with the same clause or the same process, then it will take a lot of time for the subcontractor to get the payments. So we need to understand like to what extent the risk will be transferred to the subcontractor. Okay, so here we have some list of main contracts and equivalent subcontracts. Like I have listed out some JCT standard building contracts. Uh, the main contracts are on the left side, and equivalent subcontracts are on the right side. So you can see that for JCT standard building contracts, we have JCT standard building subcontracts 2016. Okay, and where the main contract is JCT design and build contract, we have equivalent design and build subcontract. Similarly, major projects construction contracts, we have equivalent major project subcontracts as well. JCT intermediate building contracts, we have both JCT intermediate building subcontracts as well as JCT intermediate named subcontract. If you are dealing with named subcontractors, then they have specific intermediate named subcontract for JCT. JCT intermediate building contracts, we have intermediate subcontracts for subcontractors design. Similarly, for FIDIC, we have two subcontracts, one for Red Book and other for Yellow Book. The Red Book was published in 2011, the first edition for FIDIC Red Book subcontracts. And second is about conditions of subcontract for plant and design build. That's the first edition, was published in 2019. So, so this is clear that when you are working with any specific form of contract, we have equivalent subcontracts for those form of contracts as well, that we can always advise our client or our management to first have a look on the subcontracts. And if you find that something needs to be modified, then you can draft it accordingly. Now we'll discuss about the procurement of the subcontractors, how to appoint a subcontractor. Okay, so basically for the procurement of the subcontractor, we need to understand what type of subcontractor is being appointed. Okay, for what type of work they are being appointed, because different subcontractors have their different way to appointment and procurement. Right, the nominated subcontractor is appointed in a different way. The domestic subcontractor is appointed in a different way. Okay, so let's see in case of how a subcontract is appointed in case of a provisional sum. Okay. So as we know that in provisional sum, a subcontractor is deployed under the main contractor. So the main contractor is involved in preparing the design and specifications. They review the design and specification that is given by the employer to the contractor. Then the contractor reviews it and prepares the scope of work. The role of the main contractor is to review the design and preparing the scope of work. Then they will prepare the BOQ. Then the tender documents will be prepared by the main contractor, and it will be given to the project manager or somebody of the employer, like maybe engineer from the employer side. They will review it, all the tender documents, and finally the tender document will be issued for tendering, right? Now, before going to the tendering, the main contractor will prepare the tender list. It is written here that the list of minimum 8. So it depends on means client to client and their methodology, like how many tenderers they generally. What is the minimum list of the tenderers for going forward for the tendering? So that list will be there, and then a pre-qualifications will be done. Next to that, the project manager will review and recommend to the employer. So once the pre-qualification is done, it will be the tenderers, the list of the tenderers will be recommended to the employers. Next to the employer's approval, employer may omit proposed tender or any additional tender. Then the contractor issues to the tenderer the following, like expression of interest and confidentiality undertaking. It is done through the main contractor only. Then minimum 6 positive responses are needed. The contractor issued the final list for approval. Right? And next is about the project manager reviews and does the recommendations. So the essence of the entire this process is about, in case of the provisional sum, the main contractor is involved in the entire tendering, assists the employer in the entire tendering process, starting from the preparation of the BOQ, starting from formulating the tender document, then to floating the tenders, then attending the tender meetings, pre-qualifying the tenderers. This entire thing, the main contractor will be involved, and finally the contractor will be selected to execute the provisional sum. Now, how the payment will be done to the main contractor? The payment will be done, like the actual expenses of the provisional sums will be taken into considerations, plus the overheads and the profits, which are already mentioned in the contract, will be added to the actual expenditure of the provisional sum. And the entire provisional sum will be treated as a variation. So it's governed by, as a variation in the profit. Okay. Okay, now let's have a look how we can draft a good subcontract. Basically, I have highlighted few issues of subcontract which should be taken into consideration while drafting a good subcontract. There are various issues actually, but within this small span of time, it is not possible to discuss all the issues that should be considered while drafting the subcontract. I have listed out few, the most important issues basically, which needs special consideration. The first one is about the failure by the subcontractor to perform. It is a very common phenomenon in the projects that subcontractors fail to perform, maybe at the middle of the project, sometimes at the end of the project, uh, or because of their insolvency, maybe because of their cash flow issues, or any other issues, maybe incapability, right, to provide quality service. So, or delay may be there, right? So if the subcontractor is not constructing the subcontractor with the required quality failure is very common, or it's not proceeding with the subcontractor's work properly, or is causing delay. So what you can do in a subcontract in order to protect yourself uh, uh, during the execution of work. So as a main contractor, you must see that if the subcontractor is unable to perform, there should be a mechanism in the contract to replace the subcontractor and to bring in some other subcontractor to do the rest of the work, even if there is a delay. Now, there must be the provision also to add some resources from the main contractor's in-house team to expedite the process. Sometimes what happens, like main contractors provide their own in-house resources if there is a delay to mitigate it. Okay. So this should be clearly mentioned in the contract, like with the different eventualities, like if there is a delay, what will be the rights of main contractor. So the main contractor can add up the resources, additional plans, machineries to accelerate. Okay? And if there is a failure in the quality, so they can terminate the subcontract, or they can give it to the other subcontractors. This should be mentioned there in the contract. Okay, now if the nominated subcontractors fail to perform, now the nominated subcontract is a concept of bidding, as we have already discussed. They are nominated or imposed by, basically, by the employer to the contractor. Okay, but yes, the main contractor can object to the nominations. There are a list of events for which the objections can be made. Okay, like you can see that the subcontractor here, the point A, the subcontractor does not have sufficient competence, resource, or financial strength. The main contractor can object. B is about if the subcontract does not specify that the nominated subcontractor shall indemnify the contractor against the negligence or the misuse of goods by the nominated subcontractor. So if there is any negligence of negligence in work or the quality issues by the subcontractor, he must indemnify the main contractor, against this negligence. Okay, and the next point is about if the subcontract does not specify. If the subcontract does not specify that for the subcontract works including design, the nominated subcontractor shall undertake to the contractor such obligations and liabilities as will enable the contractor to discharge the obligations and liabilities under the contract, or indemnify the contractor against and form all obligations and liabilities arising under the connection with the contract because of any failure by the subcontractor to perform the obligations. So if there is any failure by the subcontractor to perform the duties, he should indemnify the contractor against it. Okay? But if the subcontract is not mentioning all these things, then the main contractor can object to the nominations. Now the question comes, like, if the objection has been done by the main contractor, even though the objection is done by the main contractor, the client has continued to work with the nominated subcontractor forcefully, then what are the measures for the main contractor to protect himself or herself, right? Like the main contractor has made the objections, but the client has not agreed to it. Means client has neglected it. Okay. Now, what will be the scenario then? Means how this contract will be governed. There is no such clarity. So while you are drafting the subcontract, you must think about it, how we can minimize the risk if the client means carry on the work with the nominated subcontractor who was objected by the main contractor. The second is about the contract must clarify, like, how much or up to what extent the main contractor is liable for the lapses in workmanship. Okay. Like we have seen that if there is any failure of the performance of subcontractor, he must not take the main contractor liable for that. But there may be some issues with the main contractor, like the main contractor has not been able to provide some details to the nominated subcontractors, or maybe not access to the subcontractors. Then in that conditions, to what extent the main contractor will be liable, that is not clear anywhere. Now, for the delays that has happened by the nominated subcontractor, how much the main contractor is liable, and how this event will be, contractually governed in the project, that should be very clear. Next is about what is the main contractor entitled to get EOT if the subcontractor delays. Now, as the subcontractor is nominated by the client. In case of the delay by the nominated subcontractor, is the main contractor entitled to get the EOT? So these things should be very clear in the subcontract to avoid any ambiguity and avoid any conflicts in the project. Yes. This is also an important issue of payment to the subcontractors. Mostly it has been seen in many bespoke form of contract uh, that the main contractors pay the subcontractors on the basis of pay if paid or pay when paid. Like if the main contractor is paid by the employer, then only they will pay to the subcontractor. So now the question comes, how far it is fair and feasible to the subcontractors? Because maybe the subcontractors don't have that financial strength uh, as compared to that of the main contractors. So it will not be fair enough to treat this like pay if paid and pay when paid. So the payment conditions should be mutually agreed with the subcontractors, and this should be fairly allocated. Because ultimately, if you are delaying the payments of the subcontractors with these clauses, like if you will pay the subcontractors if you get paid from the employers, that will hamper the cash flow of the subcontractors. Sometimes it happens that due to the failure of performance of the main contractors, the payment of the main contractor is on hold, where the subcontractor has no fault. Right? So in that case, what are the rights of the subcontractors? That should be very clear in the contract. Okay. Now, if you refer to FIDIC forms of subcontract, there it is clearly written that the main contractors can withhold or defer the payment of any sum in the subcontractor's monthly statement for the following reasons. Like if the subcontractor's monthly statement is less than the minimum amount. So there is a particular minimum amount for up to which the payment application means uh, uh, the minimum amount, and the subcontractor should claim more than that minimum amount, right? So if it is less than the minimum amount, that payment application will not be considered. Okay, next is about the amount included in the subcontract's monthly statement are not certified by the engineer. Now the engineer, the employer is not certifying the subcontractors, means the amount that is included in subcontractors to the main contractor. And this condition says that as the main contractor is not getting paid, the subcontractor is also not getting paid. The payment is deferred. The amount included in the third eventuality is the amounts included in the subcontractor's monthly statement have been certified by the engineer, but the employer has failed to make the full payment to the contractor. Now the employer is not paying. Although it's certified, the employer is not paying. That means pay when paid. They are not paid, and that's why the subcontractor's payment is getting deferred. So these conditions are, to some extent, can say, are unfair to the subcontractors, and there should be clarity in the subcontracts. Now, there is also one clause related to the payment to the subcontractor, where it says that the contractors shall have no entitlement to defer. Now, there are some eventualities on the basis of which the main contractor cannot withhold. Like what are those? Like the first one, the act or default of the contractor. If there is any default of the contractor for which the sum is pooled with the employer, so in that situation, the main contractor should not hold the payments of the subcontractor. Now, if the employer's bankruptcy or insolvency, going into liquidation, okay, receiving the administration. So if the employer is insolvent, now in that case, the subcontractor's payment should not be held with the main contractor. Okay. Now there is one more concept in subcontracting, that is back to back. We have already discussed, like all the rights and obligations are simply transferred from the main contractor to the subcontractors, and it is simply like copying all the rights and obligations of the main contractors and shifting it to the subcontractors, sometimes partially, sometimes fully. Okay, but it is not always the right way to do a subcontract, because it can lead to many contractuals as well as legal complications, and you have to be very cautious when you are doing back-to-back contracts, because if your main contract is not drafted well, the back-to-back subcontract will be equally bad then, right? So the flaws of the main contracts will be transferred into the subcontracts. Okay? It may not be appropriate or even lawful that every obligations are imposed on the main contractors are imposed on the subcontractors. Okay, and on the back-to-back subcontracts will not include the main contractor special requirements. So what are the main contractors special requirement? There may be some specific, health and safety policies of the main contractors. Special requirement of main contractors organization, some statutory requirements. So that will not be included if it is totally back-to-back. You have to consider like what are the main contractor special requirement that should be included in the subcontract as well. Okay, now we will discuss about the concluding part of today's discussion. It's about the insolvency. This is a very common scenario in construction projects. Many times we have seen that the subcontractors go insolvent. What is insolvency? It's about the inability to pay back to the creditors. Okay, so sometimes the company goes into liquidation. Right? So what can be done in case of subcontractors insolvency? The first thing, what you can do as a main contractor, you can simply terminate and you can recover, right, if the subcontractor goes insolvent. But if the subcontractor goes insolvent, it means impacts a lot to the main contractor in terms of the timeline, in terms of the cost, because they have to go once again for procuring the new subcontractors, and then they have to manage the delays for the rest of the works. So just doing the termination will not be a remedy for the main contractors. They have to find out the ways to accelerate the project and how to settle the accounts of the termination. That is also one point of concern in case of insolvency of the subcontractors. Right. Now, there is another scenario where the main contractors goes insolvent. So as we know that in case of a subcontract, there is no direct contractual relationship between the employer and the subcontractors. Okay, there is only relationship between the main contractors and the subcontractors. Now, if the main contractor goes insolvent, what are the different remedies, different options that can be exercised in a contract? If you are an employer, right, and you are in a contract where the main contract has employed subcontractors and the main contractors went into insolvency. So what you will do as an employer? So first you will think about the assignment of the subcontractor to the employer. Okay. And this feature is basically given in JCT design and build type of contract when it is mentioned the NEC forms of contract, that if the main contractor is going insolvent, you can assign the subcontractor to the employer, right? Okay. Now in the next option, what can be the other remedy? The main contractor can confer on the employer the right to pay the subcontractor. Like if the main contractor has gone into liquidation, so it will ask the employer to pay directly to the subcontractors, okay, and provide them the right to pay directly to the subcontractors. But it is not that easy to implement these options because there are some accounting issues over there, okay, and even if the employer is paying directly to the subcontractor, the employer's obligations to pay the main contractor is not getting reduced or cannot be totally eliminated. Employer will still have the obligations to pay the main contractor, as because there is no direct contractual relationship between the employers and the subcontractors. Okay. And it is also the violation of some accounting principles that is called pari passu principle. I'm not going to discuss into elaboration. I'll just still a little brief about this concept of pari passu. It is about, let's say, if any company goes into liquidation, then the process of paying back to the creditors should be equal and fair. Right? Now, as an employer, if you are paying to the subcontractor due to the insolvency of the main contractor, you cannot do it as per the principle of pari passu, uh, because there are other stakeholders associated with the main contractor as well. So the payment to all the creditors need to be done equitably in a fair manner, right? So it cannot be done. There are some contractual legal issues uh, that is associated when you are directly paying to the subcontractor as an employer, right? So you need to put it that in as a provision in the main contract, and that should be signed by both the main contractor and the employer. It should be there. If it is not there, you cannot go and directly pay to the subcontractor. Now, what other options can be done in this situation? We can have a collateral warranty given by the main contractor to the subcontractor. Okay, so the collateral warranty will create contractual relationship between the subcontractor and the employer, right? And through which the employer can exercise his rights on the subcontractor, right? There is another option of novating from the main contractor to the subcontractor. The subcontractor will novate it from the main contractor to the subcontractor to the employer. Okay. What else can be done if the main contractor goes insolvent? This is the question of the day for all of you, and then we will uh, conclude today's session. So if anyone wants to answer, like, what is the other way out? If main contractor is going insolvent, what can we do? You can raise your hand and I can put your mic. I'll allow your mics. Or you can even type in the chat box. We have discussed about we can assign it, we can novate it. We have discussed. Okay. Yes, Mr. Joshi.
There is one another option is that the subcontractor may approach to the legal department or maybe judicial authority for securing his entitlement in a proper way by providing the proper evidences, that is work performed under the law of the country or relevant documents, and he can get the entitlement from the judiciary authorities. I think this is the another best option. Then judiciary authority will consider his entitlement in a legal way and may give the decision to the employer or main contractor to recover the money for the payment of the prospected for the payment of the subcontractor. This is generally happen in Oman here also.
Okay, okay, that's great. That's great. Any other opinion on this? Okay, we have bank guarantees can be used here. Okay. Yes, so what we can do is simply that in case of this insolvency of the main contractor, we have fitting guidelines to terminate the main subcontractor. We can terminate the main subcontractor, and we can appoint a different main contractor in place of that terminated main contractor, and then we can create a contractual link between the existing subcontractor and the new main contractor. And that is how the things can also get done. Okay, so that's all about subcontracting. I think it was useful for the participants today. And if you have any questions, you can ask, or else we'll be concluding today's session. So I will request the participants to rate us on Trustpilot, because every week we are putting so much of effort to bring these sessions to you. Even we are doing 1 hour of session on each of the study checklist of your competencies. So you can understand to what depth we are. Okay. So this is the link of the Trustpilot. If you like our sessions, please do rate us. It's there in the chat box. Please do rate us. It will give us encouragement to do this weekly APC. Okay. We have already 4.5 rating in Trustpilot, and many of you have already rated. So thank you to all of you, those who rated us at Trustpilot. And if you are interested in availing the APC services from us, you can write to us at connect@alphalearnings.com. You can even text us. We have number over here on the slide.